So this presentation's about a question that I've been asked, which is, well, what were we meant to get from the case of Barbulescu and Romania? So as you probably remember, Barbulescu and Romania is a Article 8 case that gets dealt with by the European Court of Human Rights and that arises from an employer monitoring the use of the internet, a program called Yahoo Messenger, of an employee. And they're monitoring because the rules in the particular workplace, private workplace, where the employee works, prohibit use of the office phone, the office computers, the office photocopier for private purposes, complete prohibition on their use for private purposes. That he uses the internet more than others. They ask him, why are you using it more than others? He says for work, and then they confront him with 45 pages of use of Yahoo Messenger to correspond with his fiancée and I think with his brother. And he's dismissed and complains under Article 8. So what were you meant to get from the case? Well, I think that there's probably three things that I thought the case were useful for. The first thing is that it's an Article 8 case, but clearly it involves the positive obligation that it's not the state that is interfering with Barbulescu's Yahoo Messenger account, monitoring his correspondence. It is a private company that's doing so, and the claim is that the state has failed to do enough about this, has failed to secure enough privacy for him vis-a-vis a private employer. And so it's a case about a positive obligation. And of course, it's interesting for us because it's about a positive obligation to create some sort of legal protection against a private party, the employer, beyond the range of the standard Article 8 sort of tort that we see in England involving misuse of private information. That here it's about monitoring, about intruding on his correspondence, rather than about publishing private information about him. What else we can say is that the particular context it arises in is a contractual context. There's a contract of employment there, and that's interesting to us because of the question of, well, how far should you leave it to the contracting parties to regulate the arrangement between them? And there the European Court of Human Rights is quite interesting. If you look at paragraphs 117 and 118 of the case, then there's a sort of balance going on there, that it's said that generally you do leave it to contracting parties to regulate their own relationships. But at the same time, there's a suggestion that employment contracts are characterized by subordination, and there's a particular concern to look after the privacy of employees, that there's a clear concern that it might just be too easy for the employer to over-intrude. We'll come back to that point in a moment, because the third factor that I thought it was useful for is that the European Court of Human Rights generate a fairly detailed list of relevant factors that they put forward as being relevant in judging the proportionality of the intrusion, albeit by a private employer, on the employee's privacy. And those are put forward, and in putting them forward, the interest of the employer is described as a legitimate interest in checking that workforce is being diligent and the like. That thus the case It's perhaps interesting to contrast, or perhaps not contrast, our later case, rose last October, of Lopez Ribalda and Spain. Again, positive obligation, Article 8, again, workplace monitoring, but this time involving CCTV monitoring of people working at checkouts in a supermarket where there's a suspicion that some employees may have been stealing stock. And in that case, there's of course a property dimension to it, that the intruding company is actually losing property, is losing several thousand euros of stock each month. And so one might think, well, that there's slightly more than just a sort of disciplinary interest justifying the intrusion, though perhaps unexpectedly, the European Court of Human Rights pretty much, well, as it puts it, transposes the factors that are put forward in Barbulescu as relevant for carrying out the proportionality assessment. When we look at that proportionality assessment, two things that might particularly be worth highlighting. One is that the fact that Barbulescu has signed up to the workplace code, the code saying you cannot use the phone, the computer, the photocopier at all for private purposes, is certainly not treated as decisive. Instead, in the factors relevant to proportionality, significant importance is attached to, did he really know, was there really notification to him of the extent and nature of the intrusion, that he knew exactly how much monitoring there was going to be, and that monitoring might extend to looking at the content of the messages, not just something more generic like how frequently he was contacting various sites. Second factor that's really coming through in the proportionality type assessment is that a strong element in it is an assessment of whether they intruded to the minimum degree necessary in order to achieve their aims. And there's a strong suggestion, particularly in the Lopez Ribalda case, that's a necessary question. It's important to ask. Were they intruding to the minimum degree necessary? Indeed, the dissentients in the Lopez Ribalda case, one of the things that they suggest is you didn't actually have to do the CCTV monitoring to stop the thefts. You just had to tell people that it was a possibility, and that the failure to consider whether they were doing minimum intrusion was for the dissentients a reason why perhaps this was disproportionate. That, of course, one of the interesting things from our point of view coming through there is the question of, well, is this effectively treating employers like the state? Treating employers perhaps even more restrictively than the state, in that there's no obvious mention of them having a freedom, for instance, to decide how are they going to manage their workplace. Is it going to be a workplace where they attach huge importance to people devoting themselves and their full attention to work, or is it going to be a more relaxed workplace? One might have thought, well, maybe employers have got a freedom to make that choice. What sort of managerial approach do they want? And there's no mention of that. That instead, that there seems to be a much more almost objective sounding idea of justifications for intrusion. That if we were looking for slightly broader points to take from the Barbulescu case, then I guess that there's well, at least one that would be perhaps interesting to take from it. That, of course, when we saw Article 8 in the private nuisance cases, there we were thinking about nuisance not protecting everybody who had an interest in the home, and perhaps a need to extend tort law to provide better protection for people with interests in the home who didn't have property interests. Here, one of the things that comes through, particularly in Barbulescu, is attention to the importance of the workplace as a forum where people develop their, what the European Court of Human Rights calls, private social lives. And the suggestion is that for many people, perhaps even for the majority of people in society, that the workplace is a major setting where they get to form relationships with other people. And in consequence, we might think, well, okay, how well does private law protect those opportunities? That if your workplace is plagued by disruptive noise or disruptive smells or vibrations or whatever, and this actually interferes with the possibility of meeting people in the breakout spaces and the like, well, should private nuisance be extending into that realm as well? If we want to think about the sort of the general issues raised in the Barbulescu type case, the positive obligation setting clearly being fought out in terms of monitoring of internet use and the like of employees, monitoring by CCTV of employees. I guess a sort of similar field in which we haven't seen as much litigation yet would be employers seeking to regulate relationships in the workplace directly. Codes about what sorts of relationships employees can have with each other, what sorts of relationships they have to report to their line manager or the like. And clearly in that field, again, we might expect to have this concern about it being too easy for employers to privilege their own convenience and interests in the way in which they set the balance between their interests and the privacy interests of their employees. So that was Barbulescu.